Hi, Dr. Campbell. It's Richard. I thought I'd try and get this message to you and email you. I don't know if you've been watching some of my videos that I've tagged you in over the last sort of 6 months or so since I found your channel. There's so much to talk about, but I don't really want to talk about me. Or, you know, there's so many important things. You could literally talk for hours. But the main issue at the moment that I think that we should all be completely and totally focused on and working together is YouTube. Vobes has just had another video taken down. I didn't realise, but he's not uploaded for a week. He's just got another strike. To be honest, I hadn't been watching his channel every day like I used to do because there's so many channels to watch and I've got other things to do. And I've actually been focusing on the legal stuff for YouTube side of it. I've actually had a girl helping me that I found that she's quite good at writing. She's got like a PhD, a doctorate in history. She's like a scholar, but she's also got a law degree, a master's. So everything that I do, she like checks it over to make sure that, you know, it's not wrong. So I know that all that I'm doing now is correct. And she writes it out very professionally as well. So with the whole, I've had my main channel taken down, which it's got all the evidence on it, all the video evidence, and all the legal. It's got all the legal videos where I've been doing the actual rights that, you know, the actual rights that we're meant to be using, like all the deep discussion of rights and stuff, which is ironic. So how are you supposed to contest the rights when, you know, YouTube are taking the videos down? They've even got the legal arguments for it. So I know that Vobes is, you know, he's had a few videos taken down. I know that you've had one or possibly more taken down. Neil Oliver's just been on George Galloway, and then, you know, I know Russell Brand really is bothered and concerned about rights, and he's a sort of person who's not short of money. But I did write to Robert F. Kennedy. I asked Robert F. Kennedy Jr., I sent him messages and I asked him if he would challenge YouTube because they took some of his videos down, took some Australian Parliament videos down as well. And then he did. Robert F. Kennedy did go to court just a couple of weeks ago, but apparently the court in America said that apparently he didn't have much of a chance, but they're wrong, the court. I submitted a complaint to this court in California through the web form, and I'll show you it, and I got a letter back, but while I was waiting, I didn't expect them to send me a letter through the post from America, but I got this girl, Velma, to reformulate it into like a more coherent and consolidated legal representation in the proper format, that they like it in the proper format, you know, when it's all written out in the, you know, like all itemized in a specific legal language. So like just, you know, it looks professional basically when you submit it. And then I submitted that, and she's checked it over, but she's more into the history side. The thing with YouTube and these rights is, in order to understand what they mean and why we've got them, you have to go back in time to the time that when they made them, and why and what led to it, and what sort of things were they doing back then. And that's what we've done. And there's that Professor Karen Bowie paper, Glasgow University, on rights. And the thing is, I don't really want to undermine people, but some people don't necessarily have the attention span or want to put time into contemplating like one singular thing, whether it's one point or one thing. And often because of my own situation and being ill, the thing with what's matter with me is, it's actually facilitated or enabled a lot of focus and concentration on certain things. It's just what's happened to me, like, you know, like the whole brain fog thing is gone. So there's kind of like not any satisfaction or relief, and things become very irritating and annoying because you can't sort of get any sort of comfort, really. So you have to, but there's this kind of like peeling away of the kind of like layers and layers of brain fog, so you can comprehend things and to a much more significant and deeper meaning. And then it's sort of like exploring things around them, you know. And what has come to light, and this is a main point, is that that First Amendment in America, when most people read it and look at it, the freedom, the right to petition with the freedom of speech and freedom of the press, people think of that freedom as the press part, as if it's like the press themselves, like them, the press, the newspapers, they have got freedom to put stories or investigate or do whatever they're doing. But this is the Constitution of America for we the people. It's about the citizens, and it's about the fundamental rights, what the country will be founded on. So you don't have or need a particular right that is about a private company or business, because this is about everyone, right? You don't have... So, and when you go back to the 1688 Bill of Rights, the freedom of speech actually in our English bill is actually only meant to be in relation to political discourse, political conversation, bringing political cases, but also in private, because obviously you've got to get them together. But when you're petitioning, the petition is a legal action. It's legal proceedings. And it had, justices, grand jury and so forth involved, but they got rid of those parts of it. It is official legal proceedings, and it's just in a different format and order to a criminal or civil case. And you go straight to the jury at the start. You don't go to the jury at the end like you do in a court case. And this is when you've got the right to speak freely in public and private, and freedom of speech, and right to use of the press, right to use the telephone, right to use the electric wire. They used to have the Morse code, the wire, the electric cable, right to use the post. So that freedom of the press is grouped in with the right to send letters. Apparently that RF Kennedy case, and to be honest, I need to say this thing as well, there's legal requirements. There are legal requirements. When the council do roadworks, there's a legal requirement to publish it in the local newspaper. And when you're doing petitioning, you have to get people to sign it. And actually on the Parliament website, they're asking people to sign. They're telling people to share it on Facebook and Twitter. It says it on Parliament website. So it's to serve a function and purpose. What is that function and purpose? To get the signatures. Now, in the law, under the distribution of printed material and under the advertisement class E and F, which is protected through the use of that enactment, it says when there's an enactment, a law, an order by Parliament, or to serve a function. So that is to serve a legal function in proceedings. There's actually a legal requirement to publish through in major newspapers. Like they've got that London Gazette that you can publish things in. I tried to publish a petition in there and they turned me down at one point. I've actually won a legal case against the London Evening Standard myself, self-representing, to publish in there when they didn't want to publish the Republic petition, Not My King thing. And I actually got them published. They published it. So with YouTube, apparently that judge was saying to Robert F. Kennedy that the reason she gave is merely, so this is the basis of the whole thing, that the claim is that YouTube is privately owned. Well, what isn't privately owned? I mean, British Telecom was publicly owned, right? And Royal Mail, but, really what isn't privately owned? You can't say that because Royal Mail or, British Telecom, whatever, are public companies, they're the only ones that you've got your rights through, that would be a load of tosh. And I know that Royal Mail's partly owned by the public still, but it doesn't matter about ownership. It's the fact that what is the service for? Well, it's for sending messages and letters, right? And so in a specific area of messages and letters are protected anyway. Mail's meant to be regarded, I think someone said mail's regarded as bullying, or it's got a special letters, different from commercial goods, private communications. They've got a certain classification. But the fact is this, look at the telephone, right? Can you imagine if, right, the BT now, right, private company, what do you pay for? You pay for the line, the connection. You pay for you send a message down a wire, right? So you're transmitting, right? That's what you pay for. You pay for the wire to be available to you, right? To use it. Now, if I ring you up on the telephone, right? I'm sending you, if I upload this message to YouTube and then send you the link, then I'm sending you the message, right? It doesn't matter whether I do it through email. Google have got emails, Gmail. Google have got emails. That's private. And the policy on all of Google's meant to be the same anyway for rights. Well, it's all publicly owned, privately owned. So they can't say that they won't send the message or transmit the message. And all you're doing on YouTube is you're transmitting the message not only to a single person, but to a group of people. Like in the newspaper, the section in the newspaper adverts, public notices. This term, all rights reserved, for copyright and so forth. There's always been a reservation for political rights or those legal notices that have a requirement to be published, or else the newspapers would refuse to publish, those roadworks and stuff that the council and government are doing, which is like, how did they manage to take that Australian Parliament video down YouTube? So it's this fundamental, like when you send a letter through the post, they're not even supposed to read it anyway. They only check them, for security issues or through customs to see if you've declared it properly. It's actually not any of their business, a private letter. Now, on YouTube, you can have a video completely private, or you can set it to link share only, which you haven't officially published it really if you just put it up there and get a link, because you can only send it to who you give the link to, which is like sending a letter. So it's still not, I don't think that it's still officially published like you publish a book until you publish it to the website. But then it's on par with the newspapers. Now, I strongly believe that well, I don't believe, I know. These rights are, it's the freedom of the press is an extension of the free speech at publishing. And YouTube is not a private website. Anyone can view it in any library with an internet connection. You don't even have to join it or become a member. Anyone can watch videos and read it. And anyone can start a channel and upload for free. So it's not actually private like a private club or members only. So and if you're uploading videos for free, the classification of the material that we put up there, right? In the Town and Country Planning Act, anything that's a word, letter, message, representation, anything like that is considered as an advertisement, right? On Google Ads, you can pay to advertise, but when you're uploading videos to your channel, at the end of the day, it's just content material. And it just class under advertisements, particularly if you're promoting something. And for political things, in England, the Advertising Standards Agency govern YouTube anyway. And they don't govern political material because they're not allowed to take it down because it's exempt because of class E and F, which is like when you put notices up in public, right? Under the Town and Country Planning Act. So when you upload, effectively YouTube is like free ads because you don't have to pay to have a channel and upload, right? And you can upload, you can advertise things to there, like advertise your petition, or, when you're calling on the government for something or calling for local people to support you or anything when you go into the subject of politics. So there's absolutely no way at all that YouTube can take the political rights away. And another way of looking at it, which is an important insight, is that what YouTube are trying to do is they're trying to say, look, they've got these political videos on there, political genre, but they're trying to say that, they don't apply the right. The right is the governing law for that genre, right? So they can't strip the law away from the genre. So whenever and wherever you've got political content material, it's governed by the appropriate political law. Applies. You don't strip it away like the soul. It's almost like taking your shadow away from you if you strip your shadow off. Like, you've got smoking laws, but when you go into someone's private house, they don't strip the smoking law off you and say this doesn't apply. The laws for where you can smoke and what you can smoke, you see the smoking law, and the law tells you where you can and can't smoke and what you can and can't smoke in whether or not it's in public or private. The law tells you, not the person in the private house, right? If the law says, you can smoke in a private house, then you can. So what the concept of what YouTube are proposing is, they're trying to say that once you've gone into this, private website, the law doesn't apply to certain things, but it does. And my other example was this. This is an absolutely brilliant example. According to YouTube, by their philosophy, if they claim that, because it's private platform, then why aren't they putting in their policy, copyright law doesn't apply. No copyright applies on our platform. We don't have to apply it because it's one of our policy clauses. As if they could do that. So, why are they collecting money for Warner Brothers and Universal Studios, right? Collecting all this money in, right? For them on their behalf, and then scanning all the videos to see if you've copied anything, right? If you can use it or not. They're doing it not out of the good of their heart. They're doing it because the law compels them to, and they're collecting money for, Universal Studios and Warner Brothers. So all that whole framework for scanning, why didn't YouTube just make it easier for everyone? If it's if YouTube don't care about the law, why didn't they just say, well, we don't have copyright on this platform? Well, they can, because copyright applies to people's material, people's protected material. Ironically, I don't think, copyright doesn't apply to political material because you're using it in proceedings as an exhibit of evidence, as if it were being used in a legal case as evidence to demonstrate something, to show something. You're seizing the material to make a point or make a legal point or a political point or as a demonstration. That's what's happening, right? Like fingerprinting or a picture of a painting that's been stolen or something like that. But in politics, you're not proving a criminal case or you're not proving a civil case. You're proving a political point. So, this is it. And if YouTube actually are saying, we like doing copyright, we want to do copyright, we're a good little platform on behalf of our White House and the nation and these companies, then are they actually on the side of those companies, and trying to make money for them out of us? Is that what it's all about? But the fact is, they want to protect copyright. They want to be good citizens, do YouTube admin, the owners, Google, and they want to protect copyright and cash in the money on behalf of, the copyright holder. So, but this, ironically, they don't really want these political rights to apply to political material. Political rights apply to political material as much as copyright applies to copyright material. Now, I don't know how Neil Mohan and YouTube really truly believe that they can strip the soul away from it. And the law applies to the thing itself. And the governing law for the political material is that you can't be prosecuted or held to any commitment. Well, they're trying to hold you to a commitment. It's just the model of it. No matter how YouTube want to go into any detail of any clauses whatsoever, it's like the same. It has to be the same as the post in the mail, therefore email as well, which is Google, and like the telephone line, like they're all privately owned. Well, they used to be publicly owned, but there's always been private ones. you're paying for. You're actually paying when your postman comes. You're paying him to come and collect an envelope sealed and deliver it. Now, it's none of his business what's written on it. You're paying him to carry it, right? He's a carrier, right? He's not even meant to look at it if it's confidential, right? If it's confidential, he's not even supposed to read it anyway. And on a telephone line, there's not going to be people listening in. That's going to be confidential, right? But it's a private company. The judge in America said to Robert F. Kennedy, read it in the newspaper, the quote was, our entire basis for this legal argument, they've stated what the argument is on their opinion. And it's not any other complicated technical point other than they're claiming that it's because it's private. On that fact alone, privately owned, that, the rights don't apply, or they can say that rights don't apply. Well, if that is the case, then that means that BT, as a private company, could say, we're not going to allow any phone calls which discuss this or that. And then if you're halfway through mid-conversation with, Dr. John Campbell, just hang up, cut it off. Or, if I send a letter to you, say they're not going to deliver it. Have they been intervening in all these letters and processes through all the past, when we don't know? Well, if you found out, maybe they might have been, but they're not supposed to have been doing. It's all rights reserved. In political rights, you've got the free, you cannot be intervened in, and you cannot, you can't be prosecuted or imprisoned, so you're not being regarded as a criminal. And if you can't be regarded as a criminal, there's no legal clause that they can use against you on the platform. But it's this point with making their own rules up, right? And what they're wanting to do is make their own rules up as a private company for who can, send, transmit, or publish what. Now, they can, for political matters, when there's a legal requirement to share it, there's been such strong opposition and heated debate over politics when the printing press was invented. They've already actually been through all these arguments and conflict and come to the resolution, right? Which is why they got the First Amendment. That is what it means. It's an extension of the free speech. And the thing now with YouTube is that beyond private letters and personal letters and private telephone calls, we've started to get a lot of political power, which is not to the liking of some of these big parties and some of the big companies that they've helped make very, very rich by setting all the laws and rules. And they don't like it, but it's tough. Now, I think Robert F. Kennedy was saying that, they come out with this it's detrimental to the company. Some of the things are detrimental to Google. But that's the thing. You can't have BT saying that, if you started ringing people up to tell them to sign a petition to get BT back under public ownership and take it away from BT, it would be like BT, listening into calls and then hanging everyone up. If you try to ring people up out of the Yellow Pages or phone book to get them to support a petition or political siding, for example, to side with you on getting BT back to public ownership, then they cut your service or deny service. It's a little bit like debanking Nigel Farage. They can't do it. You're paying for a connection, a wire, right? And they shouldn't be reading your private or personal letters anyway. And the fact that you've been politically exposed or whatsoever, you're politically exposed in the newspaper. You're meant to be politically exposed when you want it in the newspaper because you've chosen not to keep it private and confidential. You've chosen to put it in a published thing, and public notices are public notices. Now, these newspapers, they enjoy choosing their stories that people come to them with, or making their own stories up or whatever, writing them in the newspaper. They get all this money from advertising businesses. There's meant to be discrimination laws on that, for colour, race, sex, and so forth. They just don't like the way it's going. And these are very, very well-established laws that have been going for a long, long time. And there isn't anything really too much complicated about it other than the First Amendment and the Bill of Rights. And there isn't really any other, there's no deeper technical words and clauses to need to delve into. It's knowing it's already written in those base acts, in those bills, in those laws. And where the value is what does it mean simply and why? And when you go back to look at it, it tells you, because they were trying to charge people for even doing petitions or, not letting them speak freely, even in their own private houses. They were trying to stop them talking about religious matters or certain things, even in their own house, even in your own private house, let alone publishing it in the newspaper. They didn't even want people to talk about it. So, never mind Neil Mohan on a private platform saying we can't talk about what we want. If Neil Mohan doesn't like it, they were trying to stop people even talking in their own houses, having meetings in their own private house. Police would go around and arrest them. So you got the freedom in private places. Publishing, the newspaper has this section of public notices, and it's meant to be reserved for things that have a legal requirement to be published by law or serve as a function or purpose, like petition signatures or public consultations, which have to be sent to many people or shared. And it's always, you aren't going to send a letter to every single person because it'd cost you millions. That's why you put it in the newspaper, and they publish it for people. And we have these rights in order to do notices to the public notices. You can choose to go private and ring people up, but it's not, the legal argument was not that you're publishing it to the public. That wasn't a legal argument. It was purely on the basis of privately owned. Now, if they can't have it on the basis of privately owned, because or else they will be able to just shut off people's phones, refuse to deliver letters, and we would be completely and totally compromised. If they could have the argument that, because it's privately owned, you don't have your rights on there, that's literally, you're looking at having they're having the power to refuse to deliver letters, to shut your phone line off because it's a privately owned company, not even have an internet connection, and, completely and totally, not even send emails be delivered. And at the end of the day, the ironic thing is that Google, their policy on Google, it's Google Mail, Google Emails, and, YouTube and Google Ads. So, we've got all this written down, and I can send you the documents, but what I've sent a complaint into that court. We really, for the sake of brand, for the sake of your channel, for the sake of verbs, for everyone, we need to get these channels and videos restored, because it's not fair. We're having our liberties and freedoms subverted. And the Bill of Rights, those rights were created because what they were doing to us, the judges, the ministers, and the councillors, they were subverting the rights and liberties of the realm. Blocking free speech and the right to petition is something, it's a wrongdoing, and it is illegal in that bill, and what it's classed as is a subversion of the rights and liberties of the realm, even contemplating doing it. And that is why they've got Congress shall make no law. They can't make a law. And the fact that Biden's even contemplating talking about maybe we should, the fact that they've even got people, even now, they've managed to get everyone even arguing now whether we should or even shouldn't have free speech. To not have it is illegal. He says Congress shall make no law. So it's even now getting people to contemplate we're on the side of Biden, that they're even, some of them are even saying that maybe we shouldn't have free speech. So to even entertain that line of inquiry is against the First Amendment, and that is contemplating subverting the laws and liberties of the kingdom and of the United States, which actually, that is treasonous. They're actually locking Trump up. Apparently, they're going to try and prosecute him for just getting a lot of people over to the White House. But what Biden's actually doing, and they're doing all these law cases with Hunter Biden, there's a distraction for Biden and Google to even think about and even claim, for them to claim that we haven't got free speech on YouTube, and for Biden to direct YouTube to take material down that's got a political right. And let's get this, like, apparently, when you've got a petition, apparently Parliament can make a decision on it. But we're talking about collecting public support. Apparently, if you submit a petition with evidence, right, if it could get actioned, right, on, less signatures, but I think what Parliament and Congress are trying to make out is that, because it's a case to the government, they can make a decision on it at any point and say, we don't even think that's true, take it down, right? But the thing with the petitions is that you're collecting the signatures of the public to say whether or not they think that it's true or not. And then you hand it in and lay it to Parliament, and then Parliament are allowed to debate it until you've handed it in. In fact, until you've handed it in, Parliament don't even really want to acknowledge them, except now they're starting to, tell people to pull stuff down. So the part of it where you show material to the public and get an opinion on it, it's trying information. In a criminal case, you're trying information. It might be true, it might not be true, right? But it's for the court to decide, or the jury. And what's happening now is that in political matters, this is the whole misinformation argument. The whole misinformation argument is fine if it's just, normal discourse. But then again, when you're publishing exam results that are wrong, you're publishing misinformation, but it gets a mark next to it. I don't know why YouTube and, the government just didn't start asking YouTube to put like notes or a symbol at the side of videos that have been reported as to be untrue, rather than stripping them down and taking away people's material that they've recorded. It could easily be marked as wrong, like at school or whatever, rather than... But the fact is, they're trying to stop... They don't want people to have the free speech. That's the problem. For politics, right, it's different. You've got the freedom and liberty because you've decided to engage an information, fact or any information, and you are showing this to the public with the question, what do you think to this, or what should we do about this? And the public have got a right to an opinion on it, and this is trying information, and this is why it's a legal proceeding, right? It is the trying of you're trying the information. It might be right, it might be wrong. In a criminal case, it might be true, the statement might be true or not. But, the jury have to hear it, right, to decide. The court has to hear it. What Biden and Parliament can't handle and don't like at the moment is the fact that we have a right to take it outside of the courtroom, outside of the civil, outside of the county court, outside of the Royal Courts of Justice. They don't like the fact, and they can't handle the fact that there's this open public proceeding, which is a legal proceeding, an ancient official legal proceeding, fully protected. And it has a slightly different ordering to inside the courtroom. You first go to the jury directly, to the people, and you show them the informations. And the people who agree with the informations that you're trying mark their support. And then you lay it to the Parliament. And on the basis of the weight of the support of the public, Parliament debate it, taking also into consideration how many people support it or not, right? And if you got 3 million signatures, you could, literally... You could make Parliament, say, redefine the terms days, night, and night is day if you wanted to, which is what they are doing anyway, redefining all their terms, election misinformation rather than illegal, election intervention, which is what they're doing to Robert F. Kennedy Jr. So And I don't know why the Australian Parliament, they must be in on it, because I don't know why they let YouTube take their video down. I don't know why Australian Parliament hasn't sued YouTube, because when there's a legal requirement to publish a roadworks or something like that, the newspaper suddenly start refusing to publish any of the roadworks in the newspaper, or we're not publishing them, it's a private newspaper, the council would soon be onto them and taking them to court. So I think the Australian Parliament are in on it, because otherwise they'd have already taken YouTube to court. What I would like to ask is that, we need to get some legal help, and I don't mean black belt barrister, because I don't necessarily think black belt barrister's on our side, to be honest. There must be a lot of lawyers who watch John Campbell channel or Verbs or Brand. I mean, we need to. I mean, I don't really want to go on, myself, but I'm hoping that you can at least consolidate all this and, brief it into a more shorter thing. We need to ask, will any lawyers come forward pro bono who are on our side and don't want to throw it, and genuinely, can they volunteer to sue YouTube? Like Robert F. Kennedy was doing, but in England, I think they've got an address in London. We can take them to court in England. If it's got an address that you can write to, you can take a company to the court, right? And we need to get voluntary lawyers to help us and do the case. It is the freedom to use of the press. It's not the press's freedom. The First Amendment of America is not there. I've got deja vu again now. I'm sure I feel like I've sent you this message before, but I definitely haven't had your email before anyway, that's for sure. We've got to ask, we need to get, Neil Oliver, Brand, yourself, or Verbs. Some of them have got some lawyers who watch their channel who will, help. And we need to get YouTube taken to court. Because otherwise, Verbs has just had another video taken down. You've got no idea when they're going to pull the next Campbell video down. We've got to do something about it. And then once we prove the political rights on YouTube, then, all of us are pretty much engaged in politics now. We can start, uploading. Well, I think you've got a few petitions on there, but there's no doubt about it. We are all now immediately engaged in political emergency, and it is it's engaging and getting people to support causes so we can get action on it, particularly with the WHO and things like that. So I think it is the most important thing at the moment for all of us. And then at least, people can, otherwise there's no stability. There's no stability to any political action. It's a legal proceeding. It's a legal proceeding with a requirement to be published, spoken about and shared, supported by legislative process. And, we're gonna, the media are, they're prosecuting Trump and Biden for all the wrong things on purpose. They're distracting away from the things they should be charged with. The concept and idea of what they've been doing is treasonous. In fact, directing that 77th Brigade or Battalion to take stuff down could potentially be treason. But apparently they're claiming that they were only taking down other countries' stuff, not patriot stuff of our own country. But 77 Big Brother Watch said that some English people's stuff had been taken down in the process. But what they're doing, they've got us caught in the crossfire, because the Americans were taking English stuff down because it's based in America, and then the English were taking the American stuff down. So what they were doing they'd stitched us up. They were treating us as foreign. When YouTube and Google claim that it's world friendly to all nations and comply with the laws of each country, yet we've got as the CIA and the 77th Brigade taking down the opposition's material when we're meant to be friendly nations. So I mean, it's we need to get some legal assistance, some voluntary legal assistance, because I don't think many of us have got that much money. And I've been getting what I've studied and contemplated written up and checked, and the lawyer the researcher that I've used, who's quite cheap, she can't do any legal proceedings to court, but not in England anyway. She at least has checked, what I've written, and it's not a load of rubbish because she's got a law degree and she's helped me with the history research and so forth. So, it is sound. It's not a load of rubbish. We've got to make a big challenge against YouTube, I don't see how we, even if, I know that you usually ask them to make donations for this and that and so forth. We shouldn't really need group litigation, but, there's always, getting Brand and Verbs and yourself and Neil Oliver to get people to, put money in. But there should be lawyers who are on our side, who also are annoyed with their material getting taken down from YouTube, surely, who will volunteer. We've got to get some voluntary lawyers to get this matter sorted out with YouTube. Then again, maybe you think if Robert F. Kennedy is meant to be a professor, can't do it. But I think that we can, I think we can do it. And I think we should do it to YouTube from England, in the English courts, because the basis is correct.